matter that was brought, well, it's given an LC number, but it was really a special action to the Superior Court seeking the documents. In other words, why do I care? Let's assume that I find there's some kind of harassment and assume even that that's allowed. I still don't know that I can say that the documents won't be ordered just because you're harassing the district. Is there some legal basis under which I can deny documentation to Mr. Videen if he is vexatious or harassing to the district?
We think that under the first request that you can deny that based on the Lake decision, because his true target is the email addresses of the residents. The district has had a number of people very upset over that, and we have done what we can. We have also offered to give them redacted versions of this category without the email addresses in them. And then as to category 2, they are asking for a federal tax return form. That's specifically barred under 25 U.S.C. section 6103, which does not just apply to the Internal Revenue Service, as opposing counsel said, but does apply to anyone who has access to those kinds of information. The statute is very clear that it does apply across the board to all persons. And there are, after this blanket prohibition, a whole set of very explicit circumstances in the statute under when a federal return can in fact be made available to a law enforcement agency, a state, or that kind of activity. Hasn't
both an ombudsman and the Attorney General's office determined that the documents, at least some of these documents being requested, should be produced or should have been produced by the district?
Well, no, not if you're talking about the 1096. The original request was for 1099s, the documents that are prepared by, for a contractor who has done service for the district. We denied those on the basis of this federal statute. The ombudsman went to the Department of Revenue, which supported our position and backed off. Now, the problem with going to the ombudsman is, first of all, the ombudsman is not an attorney. Secondly, while he does have an attorney working for him, the district cannot rely on that legal advice if you even assume that it came from the attorney working for the ombudsman and not the ombudsman. So the district, we did extensive research under 6103, and we could not find a provision that would allow us, getting past the 1099 form to the 1096 form, to turn that over. I mean, obviously they didn't want a blank form. They can get that off the internet. What they wanted were the forms that IRS created for entities in business to bundle other forms and send them together in a package. There is nothing, I mean, the Internal Revenue Code's provisions with regard to what can be disclosed and not are, of course, set by Congress. They're not set by the Internal Revenue Service. The fact that they come up with another form doesn't mean that somehow they can say, yeah, you can give that to somebody. Does
the statute say that the forms can't be produced by the taxpayer, by the filer, or does it say the IRS can't be required to turn those forms over to someone else?
It says any person. Now, most of the litigation and most of the issues are related to what the Internal Revenue Service can and cannot do. But it